Hello everyone, my name is Bharat Konda. I'm a trademark attorney. Today I'm going to discuss about the importance of a trademark attorney for trademark registration purposes. In this video, I will cover 9 trademark topics that are relevant to trademark registration. They include: first, I'll talk about whether you can trademark for free, whether you'll be able to get a trademark registration without the help of a trademark attorney. A lot of startups have this question. Second, I'll discuss about whether you need a trademark attorney. Third, I'll discuss about why you need to hire a trademark attorney. Fourth, I'll discuss about how a trademark attorney helps with the trademark registration process. Fifth, I'll discuss about what is a trademark office action and who issues the trademark office action at USPTO. Sixth, I'll talk about what are the trademark office action types. Seventh, I'll discuss about how often a trademark gets an initial refusal. Eighth, I'll discuss about how a trademark attorney responds to this initial refusal with substantive legal arguments. Ninth, I'll talk about why a foreign trademark applicant need to hire a US trademark attorney. Let's talk about each one of them in detail. This will help you to understand about the importance of a trademark attorney. Coming to the first point, can you trademark for free? Will you be able to get a trademark registration without the help of a trademark attorney? If you are planning to apply for a trademark all by yourself, then you have to do a lot of things right before you are granted a trademark by United States Patent and Trademark Office, that is USPTO. You have to conduct a comprehensive trademark search of all databases, including federal, state, common law, domain names, etc., and analyze those search results for any conflicts. You should not end your search with just federal database at USPTO. That is not the right way to conduct a search. It is plausible that you may trademark for free without the help of a trademark attorney. However, it is highly risky for a trademark approval process. This is why 70% of the trademark applications are initially refused. You may need to respond with additional evidence, including specimens, etc., often citing legal citation, including case law, statutes, etc. A trademark attorney is well equipped with dealing with these matters compared to an individual applicant. Second, do you need a trademark attorney? If you are a US citizen or a legal permanent resident or a green card holder, then you may apply for a trademark registration without the help of a trademark attorney. Organizations with a principal place of business within the United States are not required to hire a trademark attorney. That means if your organization is in any one of the 50 states conducting business, then you don't need to hire a trademark attorney. This is a basic minimum legal requirement for whether you need to hire a trademark attorney or not. If you are a foreign trademark applicant, you must hire a trademark attorney from United States. During the process of your application at USPTO, you may want to invest in your brand and logo. However, it may become unsure whether you will be able to obtain registration. Inadequate filings, for example, without searches, may lead to denials. Therefore, the simple answer whether you need to hire a trademark attorney is no. Third, why hire a trademark attorney? For any successful business venture, brand recognition is essential. To manage the brand of your business, it is beneficial to have a federal trademark registration. Generally, entrepreneurs and startup businesses looking for cost-effective ways to get a trademark registration, right? Everyone wants to get the trademark registration for low cost. However, a self-help trademark application may not be the best option because of the multiple nuances involved in the trademark registration process. Due to ineffective trademark filing, the process may prolong longer than usual and most probably lead to rejection of your application. Fourth, let's talk about how a trademark attorney helps with the trademark registration process. A trademark attorney usually starts with the analysis of what is your brand name, how can customers recognize your brand name, which can eventually lead to a federal trademark. Then, usually a trademark attorney like myself included, conduct a comprehensive trademark search. This helps filter out any competitors that may have a federal trademark registration. Search also shows use based on common law with a similar brand name, domain name, etc. Further, I will extensively review the search results for conflicts and undertake the likelihood of confusion analysis. I will discuss about likelihood of confusion analysis in another video. I will determine what type of mark that needs protection, standard character mark or design mark or stylized mark or both. I will figure out the appropriate international class for your goods and or services. You may choose multiple classes, however your trademark application fee also goes up, including your attorney fees. Then, based on my consultation with clients and analysis, I will make a choice between TEAS Plus or TEAS RF application. The difference between TEAS RF and TEAS Plus is TEAS RF provides a lot more flexibility regarding international classes and description of your goods and services, whereas TEAS Plus provides less flexibility and you need to select from a predetermined list provided by the USPTO. And there is also a price difference between each of those. The trademark application fees for TEAS Plus is $225 per class, whereas for TEAS RF application, the trademark fee per class is $275 per class of goods or services. It is always dependent on your situation whether we are choosing between TEAS Plus or TEAS RF application. Attorneys usually prefer TEAS RF because they can write the description of goods and services by themselves rather than selecting from a predetermined list. You need to have a specimen to show use in commerce. The specimen should at least be substantially similar to the mark used in the diagram. The specimen can be in JPG or PDF format. Most of the trademark applications are currently in-use applications. However, for intent to use based application, you need to sign an affirmation that you will use in the future. Then you need to apply for electronic trademark application on the USPTO website along with the USPTO fees. The USPTO fees is dependent on the selection of the number of international classes. The international classes selection is based upon the type of goods and services you provide. Once you submit your trademark application to the USPTO, the USPTO examines your trademark application in the order they receive it. It takes about 3 to 4 months before they can process your application. Now coming to the fifth point, who is an examining attorney, why he or she may issue an office action. The examining attorney works for the USPTO. The examining attorney conducts a search of your mark. They conduct this comprehensive search to review whether there are any competing marks in the market. They do state database search, they do federal database search, they do common law trademark search. They also review any domain names that may be competing with your trademark and analyze based on case law, statutes, and any and based on trademark manual. And now coming to our sixth point, what are the trademark office action types? The examiner may issue any of the following office action types. There are four of them. First one is called examiner's amendment. Second one is called a priority action. Third one is called a letter explaining the basis of refusal. And the fourth one is called examiner's amendment combined with a priority action. Sometimes additional disclaimers are needed along with your answer to an office action. A few times your mark may end up only on the supplemental trademark register. I will discuss about the differences between principal and supplemental trademark register in another video. For now, please remember that the principal trademark register should be your preferred form of registration. Generally, arbitrary, fanciful, and suggestive marks are inherently distinctive. You want your trademark to be distinctive. These distinctive marks are registered in the principal register. However, due to the descriptiveness of your mark, sometimes some marks that are descriptive, generic, may not be registered on the principal register. They may sometimes be registered on the supplemental register. Even further, generic marks are not even registered on the supplemental register. However, due to the descriptiveness of your mark, your trademark may be placed on the supplemental register. These descriptive marks may acquire secondary meaning through use after a period of few years, depending on the strength of the marketing channels used and wide recognition in the industry. Even then, supplemental register is better than no registration at all. Always your preferred choice should be principal register. So the order of preference is principal register, supplemental register, and no registration at all. Eighth, how a trademark attorney responds to the initial refusal with substantive legal arguments. Once the examining attorney sends an office action, uh, the trademark attorney reviews the office action and looks for any arguments that he or she may make in the response to the office action. Trademark attorney response depends on the nature of the office action issued by the examining attorney. There are several types of refusals that may be issued by the examining attorney. They include: number 1, ornamental refusal; number 2, trade name refusal; number 3, informational matter refusal; number 4, scandalous or immoral matter refusal; number 5, likelihood of confusion refusal. This is the most important one. Number 6, descriptiveness refusal; number 7, geographical significance refusal; and number 8, surname refusal. And there are several other types of refusals, but these are the most important refusals, and these are some of them substantive ones. Once the trademark attorney reviews these refusals, they will look at the case law, they will look at the statutes, and plan accordingly how to respond to these refusals. Once the examining attorney receives the response to the office action, the examining attorney reviews the response, and if he or she is satisfied with the response, then the mark will be published in the official gazette. Anyone who wants to oppose may do so within the 30-day period following the publication. If there is no opposition within the determined time frame with the USPTO, then you may be issued a trademark. The entire USPTO trademark registration process may take anywhere from 8 months to 11 months. Sometimes it may take closer to a year due to the additional queries involving office actions. Most of the time, these additional queries are part of the process. If someone who is not a trademark attorney or a trademark lawyer for that matter provides services, then the process may drag on longer. It is in your best interest to hire a trademark attorney. Why hire me for trademark legal services? I offer comprehensive trademark search, trademark registration with USPTO, office action response, trademark renewal, trademark monitoring, statement of use affidavit, trademark assignment, any incontestability affidavits, etc. I also offer copyright registration services. Please check my website at affordabletrademarkattorney.com. You can contact us via phone at 612-440-1784. You can also email me at info@affordabletrademarkattorney.com.